Welcome to our Downs Racklin Martin webinar. Your website looks great, but does it violate privacy laws? I guess I want to start out by introducing us and who we are. And I'm Matt Borick, a director here at DRM, and co-presenting with me is Jenny Drake. Jenny is an associate here, and together we make up most of what we call our privacy practice group. But we do have a couple of other attorneys who will pitch in on occasion. We have Kate Foley here, who is a contract lawyer, and also we have Elizabeth Wall, who has done a lot of work with healthcare organizations over the years. And then we also have other folks available to that we tap into as needed, given the particular issues. But what I wanted to do before we get into the nuts and bolts is sort of give you an overview of what we're talking about today. The world is changing, or it's been changing, I should say, and we've gone to a model where privacy and individual privacy of information is becoming more and more important to people. And states are starting to recognize that now. Over in the EU, they've recognized it already, but now states are coming on board to address the issue directly themselves. And at this point, we think that this is a key thing for our clients to be aware of. And so the point of our talk today is to talk about issues that revolve around information collection and processing and the like. And websites are just about one way that occurs. And so that's really sort of that's a jumping off point, but there are other ways, as we'll talk about, that information comes into play. I should note also that what we're doing here is providing information. We're not giving legal advice, so there's the lawyer disclaimer that we must do. But again, this is for informational purposes only. And if there are particular legal issues that anyone is seeking input on, they're welcome to contact us so we can talk about that. So with that backdrop, what I thought we'd do is give you a little bit of a history of sort of how we got to this point in privacy law. And for that, I will turn it over to Jenny.
Thank you, Matt, and welcome everybody. We wanted to give a bit of a background on privacy in general, as it's sort of changed over time in the United States. The US Constitution actually doesn't mention the word privacy anywhere at all, but the concept of privacy is there in a number of places. In the First Amendment, there's the right to association, so meeting with other people. The Third Amendment, no quartering of soldiers in the home. The Fourth Amendment is a protection against illegal searches and seizures by the government. And the Fifth Amendment, not being compelled to speak against yourself. These all have sort of aspects of privacy built into them. But it wasn't until 1890 when Samuel Warren and Louis Brandeis wrote an article, The Right to Privacy, that sort of addressed individuals' right to privacy, or the right to be left alone from other people. In 1960, Professor Prosser introduced 4 privacy torts. Those include the appropriation of a name or likeness, intrusion on seclusion, publicity that leaves a person in false light in the public eye, or public disclosure of private facts. These sort of were distilled down from the article that Warren and Brandeis had written in 1890. And in the 1970s, we started to see where focus on information privacy arose was the Fair Information Practices and Principles, which we'll see sort of overshadowing throughout the presentation today, and we see, enforced on websites now. Enforcement regimes now currently is through the FTC, the Federal Trade Commission, and state attorney generals, and they can bring actions through unfair and deceptive practices acts, meaning that if someone makes a representation on their website or elsewhere, and the representation is unfair or deceptive, that's where you can kind of start to get in trouble. There are also sectoral privacy rules, and these fall into the areas of health information, children's information online, banking information, electronic transmission information, so wiretapping, video privacy, privacy against federal governments through the Privacy Act, and other payment card industries or industry-specific regulations or agreements that you're going to handle data in a certain way. Another thing that we started to see more recently is an introduction of data breach rules, which include state rules that address what to do in the event of a data breach or access to data for someone who shouldn't have access to it. And now I'll pass it back to Matt to take us away with sort of the specifics in data privacy and individuals' privacy at a high level view.
Thank you, Jenny. And to touch on something that Jenny just mentioned, data breach notification laws. Those were what I would sort of say were the hot button issue 10 years ago or thereabouts, because everyone was getting wind of these high profile hacks that went on. The Target breach is one that everyone seems to know about. A lot of high profile data breaches occurred, and so for a while those were all the rage. What's being done in response to this incident. What's my identity being stolen, and that's all very relevant today as well. No less important by any means. But the shift that Jenny spoke about is sort of one that you could predict in a way, looking back at the history that Jenny recounted. Ultimately, there's a word that she used, and that if any of you have worked with us before in this, we've used, and that is that fairness is the sort of overarching principle when it comes to these data privacy laws. The Fair Information Practice Principles from many years ago still permeate through all that's going on today. And it's all about being fair with the consumer in terms of your practices, what you collect and what you do with data and the like, and we'll talk more about that. But with that underpinning, let me talk about sort of how these privacy laws have evolved. The biggest step occurred well, in the EU, I should say, even before the current regulation, which is called the GDPR, there had been another regulation directive in place for a number of years that recognized and sort of codified what the folks in the EU have believed to be a fundamental right to privacy. And the GDPR, which came out in 2018, sort of ramped that up a little bit and took a global footprint at that time. For the longest time, people interpreted these the European policies to apply over in Europe, but now GDPR has stretched across the globe to anyone who's selling goods or services to residents of the EU or monitoring their behavior. Well, the GDPR now covers them. And they can be have enforcement actions against them. So that sort of started off the process, and the whole point being these values of transparency, choice, with what you do with data, rights to access your data, delete your data, rights to control the processing of your data, etc. And then, of course, the responsiveness of data collectors to those requests, another big issue. Protections has always been an issue, even back in the data breach notice days. Of course, protection was the big issue, no less so in GDPR. And so just a very omnibus privacy regulation. And so what happened, though, was that eventually that started to trickle in over to the United States directly. Now, I wouldn't say that we have people would call a fundamental right to privacy in the US, but a number of states actually do in their state constitutions mention individual privacy. Vermont does not. Vermont actually did on several occasions entertain constitutional amendments in Vermont that were going to add that, add sort of individual privacy, as a constitutional principle. But those have never succeeded, but doesn't mean that it's any less important. So what we have, though, has been a wave of laws coming in the US, starting with California, as these things typically do. California introduced a couple of years ago what we know as the CCPA, back in 2020, which was sort of their version of the GDPR, an omnibus privacy law with a lot of the same qualitative provisions, including transparency, disclosure of what you're doing, choice regarding your data, opt-ins and opt-outs, rights to, again, access and know about what data is being collected, and to have your data erased, and to have the sale of your data either controlled or stopped. And so the GDPR basically became, Americanized here in the CCPA. And there were some differences in those two regimes, but in large part they overlap quite a bit. And so with the wave of California now, we're seeing other states kind of following suit. The next state after California was Virginia, which introduced a statute that comes online here in 2023 that was very much like the CCPA, but again added its own nuances. And then Colorado and Utah and Connecticut have all put statutes in place, and these are all going to be coming online in 2023 at various points in the year. Now, not to be outdone, California, even when the CCPA was just a baby, the ink was still wet. The voters voted in the CPRA as an amendment to the CCPA, which sort of ramps that law up, and that also comes online in 2023. So some big changes coming that we know about. But then other states, at least 4 states right now, are looking actively at legislation, for omnibus privacy law. A number of states have biometric privacy laws in place. So very narrow scope, but still quite an important issue in privacy, biometrics. And at the federal level, there's now, there've been a lot of proposals at the federal level to try and implement a nationwide privacy law. And at the moment, there's a bill that's it's the American Data Privacy and Protection Act that really has had more success than any others in the past, and it's still alive, and it's a bipartisan effort. And of course, there's differences across the aisles on it, but it's showing more traction than we've seen before. And the sort of the bright side of that is getting a federal law in place helps to address, it would help to address what I see as a very difficult problem in privacy law, and that is we're really dealing with a patchwork of state laws, just like in the data breach side, a patchwork of laws that makes it very difficult to comply with. I mean, privacy law, I've been practicing law for almost 20 years, and I can say without reservation that I think privacy law is one of the most complicated areas of law, just because of its the patchwork nature of it. And there are so many things you possibly could need to comply with that it's really daunting when you think about it. Which is why I'm glad to say that, and again, those who have worked with us will know, we've said this, is that privacy law really takes a team approach, not just lawyers, but everybody involved in the process. So we all get to help each other through what can be a very tortured maze sometime. So with all this backdrop I've given about what's going on in the EU and in California and other states, you may ask yourself, especially if you're a Vermont business, you're saying, why do I care about this? I'm in Vermont. It doesn't, I'm not in California. My business is here. This is what I do. And next slide, if you would, Jolie. The answer is that it doesn't matter where you are. When we say location, it's really about the location of where data subjects are. It's not where the data collector is, and that's a very key point to make, because it's not unusual for many of our Vermont businesses to be collecting data, for example, through transactions and the like, from people all over this country and outside the country too. And just by virtue of doing that, it puts us potentially in the crosshairs of these laws. Now, I should say though that these privacy laws in all these various states do have thresholds that need to be met or exceeded before the law can apply. It's not just, oh, I have data on someone from California, therefore CCPA applies to me. There are thresholds that are set, which some of these thresholds will hinge on the number of consumers whose data you have. So if you have data on 12 California consumers, that's not going to get you there. If you have data on 100,000 California consumers or 50,000 California consumers, that may get you there. Another threshold that we see in some of these is their annual revenue thresholds. If your company has annual revenues of $25 million or more, then you're likely to fall into one of these regimes. But in at least some states that have dollar thresholds, if you're below the threshold, you won't necessarily fall into it. Some of the other states actually don't have that dollar threshold, but they do have the number of consumers thresholds. Another form of threshold that the states have would be a combination sometimes of X number of consumers, a smaller number, and you're also deriving a certain percentage of your revenue from the sale of personal information, which is not typically the case for many businesses. I mean, there are obviously data brokers and the like that's what their business is, but most businesses aren't making most of their money from the sale of data, but there are some. So, just because we're here in Vermont doesn't mean that we're not potentially on the hook for complying with these statutes. Now, another question that gets raised is, well, okay, I have to comply with CCPA, but does California really care about me, the little old me here in Vermont? And that's a very fair question. Let's face it, the Googles of the world and the Amazons of the world and the eBays of the world and the like, those companies definitely have a lot more scrutiny when it comes to things like this, both here in the States and also under the GDPR. But at the same time, you hate to be that test case for a compliance issue, and so it's good to think of it that this is healthy for your business to comply with these laws, because as we'll demonstrate, it allows you to really get to know yourself better. And Vermont, though, actually, just to finish up with Vermont, though, Vermont is considering some omnibus privacy legislation. There's some talked about in committees earlier this year, and the gist out of that was that it won't be until the next session that this stuff might start getting some more attention and traction. But it's definitely been proposed as a something to deal with. Sort of a California-like proposal was what was floated by some of the folks at the AG's office as a possible starting point for a law, plus some biometrics too. So all this stuff could be coming to a theater near you in the coming years. And so ultimately, though, you see, I've said in this slide that data is now becoming a grenade. You think about a grenade, grenades have historically data has been a big asset, right? It's been a big asset that can do good things for you. But at the same time now, that asset is also a big liability, which, grenades can be both. And, the risks of of failure to comply with the privacy statutes, including with how you do your website, to bring this back into focus, are real. Financial harms, reputational harms, of course, data breaches we talked about, misuse of data, fines, penalties, and the list goes on. So there's a level of risk now that's being created by these privacy laws that didn't exist before. Next slide, please. Thank you. So in general, what do these privacy laws entail? And I've talked about this a little bit in the context of GDPR. And again, I'll underpin it with that fundamental issue of fairness, right? It's, I'm a consumer, be fair to me and tell me, disclosure and transparency, what data are you collecting and why are you collecting it and why are you using it? What can I do about it? That sort of gets into the area of rights and how to exercise them. What rights do I have with respect to my data? Can I access and see what you have about me? Can I tell you to delete it? Can I ask you to correct inaccuracies in it? Can I ask you to not sell my data? All these pieces come in as key components of the laws, and all the ones that I've talked about so far have that element to them. There are nuances and differences between them, but in general, those provisions are there. Verifying and responding to rights and requests goes hand in hand. You don't want to just be responding to every inquiry someone makes about, oh, can you see what data you have on me? Because of course, what if it's somebody who's not the right person who's asking for the data? So it's important, to have processes in place to verify consumer requests, so you know that the person who is contacting you to correct, rectify, delete, etc., is who they say they are. I mean, we all have heard of phishing in this world, and phishing PH, I should say, and phishing is all about that. It's all about someone being someone they're not, to get you to do something that they want you to do that you shouldn't do. So same kind of concept in verifying rights. Consents and opt-outs. Consent is another a big piece of these laws, and it's not that consent is absolutely required across the board to do things with data. You must have affirmative consent to do X, Y, and Z. That does apply in some limited areas, but at the same time, though, there are certain things that do require consents in them, such as like in the CCPA, for example. If there's going to be, if you're selling data and you want to sell data of people who are under the age of 16, there's a consent required before you even do that. People over the age of 16, the consent is implied in this, but then they can opt out, so they can revoke consent. So these are, and the GDPR has even bigger consent components to it. But it's always good to be mindful of the fact that in some cases, what you do needs to be blessed, if you will, before you do it. Contracts with service providers, etc. A lot of contracts these days have data provisions in them, and they're all really designed to get at issues that have come up out in these privacy statutes. And there's when you deal with service providers who are using data that you have, and you've collected data from consumers, and then you have a service provider you're working with who's using that data for you to do some purpose, it's really important to have your relationship nailed down with the service provider, by a contract that hits the requirements that the laws will have you hit. One of the biggest ones is going to be that the service providers have got to provide just as much data security as you do, in a way, and they have to agree to assist you in complying with the law here and all that. So it's a critical component, though, in how you deal with third parties, and it also has an implication for the concept of selling. The concept of selling personal information may seem easy at first blush. Oh, I'm selling it for money. Well, it's actually sometimes more than that. If I'm giving if I'm sharing personal information with someone, not for money, but I'm getting a benefit from that, that might be selling. But depending on if you have a contract in place with the service provider, you may be exempt from selling based upon that definition. So, very key. Data protection assessments, knowing what security you have in place, always important. And then privacy policies. Privacy policies we worked on with a number of clients, and these are things that everybody knows about, with websites. Again, to tie it back to our title, these are very important parts of the disclosure and transparency piece of it. Next slide. All right, so I'm going to turn it over at this point to Jenny to talk further about websites and all that.
Yeah, so the question is, Matt's been going through all of these things to be thinking about, and all of these laws that are sort of, either in place currently or going to be in place very soon. And the question is, like, what does this mean for my website? and how does my website fit into this? So websites are really, really great, business assets. They really help consumers understand what services and goods you're able to provide. They provide contact information. They provide information about you and your business. And all of that information, is going towards the consumer, but information is coming back both ways. It's not a one-way street. And we're seeing now more and more and more websites are primary places where information is being collected. But they're not the only place where information is coming from. They're, data privacy rules apply to all sorts of data. So that information could be coming in, in person, over the phone, via mail, via email. Website's not the only way, but it is, becoming a much more important way that information is being collected about consumers or potential consumers. And to put policies in place now or a privacy program in place now is really important to be able to address where that information, what information is being collected, what you're doing with it, how it's being saved, where it's being shared, and how long you're keeping it. So there are a number of ways that information comes from a website to you potentially. Those could be direct or open collection. So for example, if someone has to set up an account to be able to communicate with you on your website, someone sets up a profile or provides information through messaging, that's all information that's being directly provided from a consumer to the website owner. Sales or signups or registrations for email lists, these are all other ways that direct collection happens, including the contact us or feedback boxes. There are also a number of ways that indirect collection happens or hidden collection, and those include cookies or pixel tags and web beacons and other trackers that are collecting information, from consumers when they go to your website or when they go, from your website elsewhere or from elsewhere to your website. This information may be collected without them sort of seeing it and providing it and having it be very obvious to them that they're providing you information about themselves or what they're doing. Another thing to be thinking about is what you're doing with that information once you've collected it. How is it being used? Who is it being shared with? And is it being sold? So Matt touched on this a little bit, but you have to be thinking both about, internally in your team, who is seeing this information, who has access to it, and what are they doing with it, and also externally. So thinking about service providers and vendors on the information that they have access to. And personal information specifically that is being provided or collected through the website. And typically the place to explain this to consumers about, what information you're collecting, what you're doing with it, how long you're saving it, how you're securing it, who you may be sharing it with is through the privacy policy. So it's becoming more and more important to have one. There are certain, rules. If you have an app, you need to have a privacy policy to sell it on the Apple Store, for example. But CCPA and other laws that are sort of coming up and coming are requiring more and more that privacy policies be present on website and be adequate. So if you have a privacy policy, the next question is it adequately describing, the transparency that these new data laws are requiring? So as an example, I wanted to go to the next slide. I chose a website. Matt helped me choose, the Atlantic White Shark Conservancy website, which is a nonprofit organization that, does all sorts of cool things, but they also collect all sorts of data, from their website in a number of different places. So just from the top bar, you can see there's a donate page, which allows you to put in information. They're working with third-party providers to collect credit card information or names or addresses so that you can donate and sort of have a message with it. They also, under their apps, they connect to an app that links to track your location and any information submitted, through the app. If you see a white shark, you can sort of ping it on a map. Anyone, has access to that information, and you're providing that through the public domain, so they can see, where you are and where you've seen a white shark. The getting involved button at the top, also allows you to provide direct information, personal information, to be able to volunteer or donate. Joining through the newsletter also is another way that websites will collect information so that they keep your email address to be able to send you a newsletter. This is all personal information that they sort of should be thinking about, all these points of collection, what they're doing with it, and how they're telling consumers, what's happening with this data. Shopping also, you can see they have hats and other swag and things that they're selling with their logos. These are all information collection spots where you can submit credit card information, financial information, people's personal addresses. And they're working with partnerships like PayPal, or more ways to give. You can sign up with Amazon Smile to be able to put in your information there, so that when you buy from Amazon, Amazon provides information or donations, and that's all personal information that's being passed between PayPal, Amazon, the American Atlantic White Shark Conservancy. So to be thinking again about third parties and vendors and relationships with, between contacts that may have access to information is a really important piece of this puzzle. And finally, there's the indirect or the hidden collection of information. There are 3 cookies on the website. I took a screenshot of the cookies that are there. But being clear about what cookies you have, how to opt out of cookies, what cookies are required or necessary, and what cookies are sort of for marketing information, and what you're doing with the information from cookies is all sort of things to be thinking about. So I'll pass it back to Matt to talk about what can you do? What are the sort of steps to move forward and things to be thinking about, so that your website isn't falling into a trap of maybe not providing what it should be to consumers and complying with these laws.
Thank you, Jenny. And to sort of touch upon some things that Jenny did mention, again, the website is just but one place where information collection is occurring. You're also collecting information over the telephone. Consumers call you. It's being written down, but it's still personal information nonetheless. So they're all kinds of places where we're seeing it from. But a website, is one of the predominant reasons that you have information coming in to your organization. And the privacy policy, as Jenny mentioned, is now a requirement from a lot of these omnibus privacy statutes. And actually, the privacy policy itself there are some dedicated privacy policy statutes that exist in some states even prior to these omnibus regulations coming on board. But even before that, going back to the FTC and the Fair Information Practice Principles, sort of to live by those principles almost dictates the presence of a privacy policy. There was never any kind of FTC directive that said, thou shalt have a privacy policy, but it was sort of made pretty clear that you wanted to have something some way that informed consumers about data use, and the privacy policy has sort of become that form. And the one other thing that you may be wondering, if you're not very familiar with this area, is, well, isn't this all about names and social security numbers and bank accounts and credit card numbers and things like that? And the answer, of course, is yes, it is. But the unfortunate answer is it's about way more than that. The term personal information has, for purposes of privacy statutes, basically is evolved to be anything that can be used to identify you as an individual. In the data breach context, it's always been about again, name in combination with social security or driver's license number, bank account, and the like. And those definitions of personal information were really geared to protecting your identity from being stolen. But in the privacy law, it's about protecting the integrity of your identity, and just the integrity of who you are and what you do. And so the definition becomes a lot broader, which leads into these what we've determined to be the 4 key pillars in our view, all of which relate to privacy policies that go along with websites. And the first aspect of that, I still think, is the most important. And it's how we always start off. For those of you who may have worked with us already, this. We always start off with the know yourself principle, because until you know exactly what it is that you are doing with respect to personal data, that ever expanding definition of personal data. Until you know that, then you're really sort of flying blind in this, in this sea of privacy statutes. You want to know, the privacy, the personal information that you're collecting from all kinds of places. You want to know what you're doing with this information, your practices. You want to know what the life cycle is of this information in your organization. When it gets there, where does it go? How long does it stay there? Who has access to it? All those things. How do we delete it? What, who do we share it with? All that kind of thing. You need to know all of that information to be able to comply with these privacy laws. One of the issues I mentioned before was the issue of sale of personal information. You may not be actually selling for dollars people's information, but again, that doesn't necessarily get you out of the definition of a sale of personal information. It may be, again, that you're exchanging personal information for some other valuable consideration or benefit that your organization is getting. Well, that could be deemed a sale unless certain other circumstances apply. And then now there's some of the newer laws, like in Virginia, for example, that one looks at not only the sale, but also, targeted advertising more specifically. And what does that all mean? So knowing exactly what you're doing with data is the most important. So when we help clients out in this area, we start with a questionnaire that we share that allows our clients to kind of dig through and think about a lot of areas that maybe they're not thinking about in terms of what they do. And it's eye-opening sometimes. Hopefully it's not, but sometimes it is. But it's just a critical stage, and it really, that's why I mentioned before that this is a team-based approach. Well, this is where your team has a huge role to play in the process of complying with privacy laws. And our job is to help probe with questions and help clarify things where we can, and then help marshal all that through. But it ultimately starts and it ends with your organization. Again, think of this as a team or as a wheel with spokes on it. We're a spoke, and in your organization there's many spokes that apply, and then together we all come up with the solution that gets you into compliance with all this. And again, it takes time to do it, to get it right. Jenny also mentioned that at the end of her discussion of the AWSC site, and like almost every site out there, there are cookies that are involved that collects information that can be deemed private, personal information under various statutes. Now, you often see on websites these days these cookie banners that pop up that help you manage your cookies and all that. That actually comes not out of U.S. law. It comes more out of the GDPR and the cookie directives over in the EU that spawned all of that, because in those regimes, for example, the EU cookie directive requires consent to use cookies unless they're strictly necessary. Like a strictly necessary cookie is one that's necessary for the website to work like it does. It's necessary for a transaction to occur. But if it's a cookie that's designed to market, to collect information to market and to do profiling, that's not strictly necessary to the use of the website, and that's a consent requirement. We don't quite have that here in the U.S. yet, but companies are still doing it in many instances out of a good practice. And a lot of clients that we see are making use of their platforms, software and app platforms they use to help comply with the nuts and bolts of these laws, and those will often include cookie banner options that you can do. CCPA, it's important because CCPA has it's not cookie banner, but it's a do not sell my personal information banner, which is kind of similar. That sort of goes hand in hand with a lot of those banners that you see. So anytime you see a website with a do not sell my information box in question there, that's the CCPA talking. So again, knowing what it is we're doing is number one. We could spend the entire time talking about that. Informing your customers gets back to the privacy policy concept. The conspicuous placement and clear drafting of policies and other means of conveying what it is that you're doing with data. So again, until you know yourself, you can't disclose what you're doing. But once you've got that, you tell them, you tell consumers what it is you're doing and what their rights are. And it's important because this sort of forms a contract of sorts with consumers. It's not a contract that necessarily is one that everyone's signing on the dotted line, but it's creating a duty on your part to do what it is that you say you do, and don't do things that you don't say you do. In other words, be honest and transparent, or fair, to use that word in the privacy policy. Respecting consumers goes hand in hand with that. It's privacy policies say this is what we do with your data and why. That's what you do. It's not this is what we do with your data and why. And oh, by the way, we're not going to tell you, but we're also doing A, B, C, D, E, and F. That is a situation where it's not fair or respectful to the consumer when it comes to their data. The other way of respecting the consumers, of course, is to be able to honor the requests that they're allowed by these laws. Again, the consumers have rights under these laws to do certain things, as I've mentioned, in terms of accessing their data or deleting and sometimes correcting and the like, and opting out of certain things. And it's critical to be able to respect and honor their wishes on that too. And of course, it comes with a with a caveat, as I talked about, and that is you want to be able to know who it is who's talking to you, because the situation comes up where someone says, "Can I please have access to all my data?" And a company says, "Oh, sure, here you go." And it turns out that this was not the person whose data it was who was asking this. Then you actually have a situation where you're in a data breach all of a sudden. And you can see that these problems go hand in hand when you think of it that way. So respecting consumers is pillar 3, and then the last piece, protect yourself. This goes without saying, but there's many ways to protect yourself. One of which again is to have good privacy policies in place. But then even going back before that and back into data breach land, of course, is having good security policies in place. Having written security plans in place in some cases. In some states, those are required, again, not because you're in that state, but because you have data for people who live in that state, like Massachusetts. Written security plan that's commensurate to the use that's being put of your data. Another thing is doing data protection assessments, assessing your data practices and your security. Sometimes those are even required by these laws, depending on what kind of data you're dealing with. If there's certain sensitive data, for example, as defined under the laws, those can trigger requirements to do data protection impact assessments. Is the processing of a certain piece of data creating more risk than benefit for anyone? Always a consideration as we look at the more sensitive pieces of data. And then data retention policies is another one. How long do we keep this stuff? Again, I mentioned data being a grenade, and there's no better example than this, and that is how long are we going to keep this data on hand? If we have data that we're not using anymore, that we have no purpose of really having anymore, there's no reason to keep it. It's as simple as that. So many of the biggest data breaches that you hear about actually involve data that's old. There was a very famous breach that happened over at Sony Pictures. It was a situation where they had spreadsheets of data on former employees from long ago still in their system in an unprotected, unencrypted format that were accessed and taken. And of course, this data had no value to the company whatsoever. But of course, it exposed them to enormous liability and ended up being exploited. And so you know what happens next. So putting together these pillars leads us to how we can help our clients. And go ahead to the next slide if you would, Jolie. we can help our clients, navigate all this. And again, I say our team approach at the top, because again, this is not a situation where, DRM is a black box and you come up with the dump truck and dump it all in, and then we grind out something on the other side and you have a widget. This is an iterative process where we collaborate a lot, and we take a lot of input and direction from you in putting this all together. And it starts again with, we do our data protection assessments and inventories of what it is you've gotten. And that's actually, I mentioned the written document that we use with our clients. So that's an evolving document as well. It's going to be updated in the coming months to reflect a lot of the stuff that's coming in 2023. And then I suppose that's a living, breathing document, I should say, because it's going to have to evolve as the laws involve. But we always start with that, because without knowing what it is we're dealing with, then there's really no point, in doing anything, because again, we're flying blind. Privacy policy work it goes hand in hand with this. Sometimes websites don't have a privacy policy at all, so we help clients draft those from the ground up. Other times you already have a privacy policy in place, and you need some review of that and some updating, which is another area that we do. Statutory compliance is, again, helping you understand what statutes may apply given what we know about your data, and then talk about ways of complying. And this, of course, brings in a whole other aspect of the team here, in terms of, on your end, it makes your IT people, whether you've got in-house or consultants that you use on the outside, they become a very critical part of the compliance piece, because putting in place ways to, again, have consumers exercise rights and respond, and have you respond to their requests and verify their requests. And there's a lot of technical stuff that goes hand in hand with that. And that's where the IT folks are very critical. They're also very critical, by the way, in step one, I should say, because no one seems to know the data better than the IT people, as it should be. So critical role for them to play. We also can help clients in drafting security policies and security plans based upon what the information they have is, and what their potential risk might be. Obviously, it's security policies get more and more important with the more sensitive level of data that you have. If you're storing a lot of financial information, that's more important than information that's just about what kind of clothes people like to buy. But at the same time, both are no less important, in terms of security. You want to have security no matter what personal data that you have. Processing agreements, sometimes these are required when you're dealing with, again, third parties in data, whether you're the third party to somebody else or someone else is going to be a third party to you. Oftentimes agreements need to be in place, and we've helped clients, businesses working with each other to develop data protection and processing agreements. And the age, the good old service of data breach response, still doing that. I've been doing that kind of work myself, since these statutes sort of came on the books in Vermont way back when. But data breach response, in many ways, is now handled a lot of times on the insurance end. Like if clients have cyber insurance, which I recommend they all have, oftentimes your cyber insurance coverage will help greatly when it comes to data breach response. And I can not undersell that enough on the cyber insurance front. And then there's one more piece that we do that I should note, and that is, going hand in hand with websites, is we get a lot of questions lately about terms and conditions. It's not really a privacy thing per se, but it is an interest that has some legal implications. I mean, there's all kinds of ways to do terms and conditions, and a lot of times what these do is they sort of set out kind of what the user of your website should expect in terms of what the website's giving them, and in terms of what it's not giving them, and trying to define your relationship with consumers based upon the website itself. And in some cases, there's been many of a case litigated about, well, are those enforceable contracts, for example? And we look at that issue, when we look at terms of service, and we'll advise on what we think in terms of how it's phrased to, how enforceable it may be. But so that's another area that goes hand in hand with our privacy and sort of cyber practice here. But there's no project that we see as being too small or not being important enough. They're all important, and we welcome the opportunity to work with our clients in any kind of any sort of services along the lines that I have mentioned here. And with that, I think that's the end of our presentation. We wanted to leave some extra time over in case anyone had any questions or comments for us, or comments for anyone else who's listening on these topics. And so with that, I will open the floor.
Matt, we did have one question come in to the Q&A. Generally speaking, are companies responsible for data on their social media channels or other platforms like Meta? Are they responsible?
And so the question being, are companies responsible for data on their social media channels? And the answer is, if the answer is yes, to the extent that you're collecting information, and you are the there's key words that go out here. There's words like controller and processor that get used in these statutes. And even though the data is existing, let's say suppose you have a Facebook site, even though the data is existing on a server that's a Facebook server, it's not existing on your own servers. It still is data that you have a certain level of control over as a collector. And so therefore, there are requirements that could apply to that data, as well as the data that's coming in from other, just on your website. So the answer is by and large yes. And again, this is where these laws get tricky, as I said, because there are other players involved, and in some cases, determining if you're a controller or a processor or a third party sometimes takes a little bit of analysis and work. It's not always obvious. Jenny, I don't know if you have anything more you want to add on that.
Yeah, I would add, it depends, I think, how you're saving it, how you're using the data. If it's just sort of a post that might be on, a social media platform, that may go into a different realm other than sort of this data privacy realm, which is the intellectual property side of things, on whether you can use it, repost it, whether you could change it if you needed to. So those are other questions or considerations to have as well. But yeah, I think as Matt said, from a data privacy point, if you're saving that data, if you're using that data for anything, it doesn't really matter, whether it's coming from Meta or from a phone call or from your website. All of these sort of rules will apply, and responsibilities apply as well.
And it's less so, of course, the information that gets posted for the world to see, on a social media platform is, that's public information, but there's information that's in the background, of course, that is collected, and a lot of things happen with social media, in terms of sharing and targeting, marketing efforts. These things all kind of go hand in hand, which is why, again, it's critical to understand exactly how your social media channels are working, and what data is coming in, and where it's going, and how it's being used. And that's where these statutes really are important. It's making you think about that piece of it. Any other further questions or comments? Well, hearing none, I want to thank everyone for tuning in, for watching and listening to us. And as I mentioned, we really enjoy working with clients.
We did get sorry to interrupt. We did get one more.
Great.
I like it.
Let's have it.
Is it recommended to have terms and conditions when someone creates an account on your website?
I would say yes, because accounts are usually like again, you're a repeat customer, and so you're coming back and you're giving information that's just identifying you and describing you, and there are transactions that are being done on the website, and a lot of times the terms and conditions are where you present those terms of sale and conditions of sale. Like I work with one client on some terms and conditions. They were a they had an online store, and their terms and conditions set forth the terms of sale, the return policy, all that kind of stuff. You'd have, if you were a bricks and mortar store, for example, you'd have a piece of paper there at the counter. Sometimes with our return policies are, well, terms and conditions are where you put that kind of stuff, because when you do it that way, you're able to make it more conspicuous too. I mean, that's another point I want to make, is that in these privacy policies and terms and conditions, the more conspicuous you make those and visible to your consumer, the better. And so, particularly though, in cases of people creating user accounts, good to have terms and conditions. And again, not all terms and conditions are created alike. I mean, some websites have terms and conditions that are really, really long, and some have terms and conditions that are really, really short. It really depends on what it is you're doing, and how much risk you think needs to be allocated. I mean, I mentioned before that in some cases, these terms and conditions are really just words. They don't have much impact if there's not a way to prove that a consumer is reading and acknowledging them. Like by clicking a checkbox, I have read and understand and agree to the terms and conditions. Some websites don't do that, and they do it at their own peril. In a way, because if you have terms and conditions on your website that are buried, that don't need to be read and acknowledged, then that's a very good argument to be made for the consumer that I never agreed to this. I don't know what they're talking about. But obviously, when you're creating accounts with people, you're creating relationships with people, and any ways that you can do to define your relationship better and create more certainty in any kind of law, I think is a good thing.
Another one came in. Who will you get in trouble with? Is it the FCC, government agency? Do you need to worry about consumer lawsuits, like accessibility issues?
Great question. And of course, accessibility issues, to pounce on that last point, that's a whole other animal. But we've seen those come in before. That's not an area that we do a ton of work in. I've gotten some of those, and I've actually referred clients to counsel who focus more on those. And these are big city counsel typically, and those accessibility suits. But in terms of the privacy, who do you have to answer to? The answer could be a number of stakeholders. The biggest one is going to be on the privacy side is Attorney General and other regulators, FTC type regulators. At the state level, that's the state Attorney General, typically is the mini FTCs, if you will, and they're largely tasked with enforcement of these statutes. The ones on the books right now tend to not have private lawsuit provisions in them, unless, like in CCPA, they actually did include a provision for private lawsuits, but it's only if there's a data breach, and then the private lawsuit is basically alleging that you didn't have reasonable security procedures in place. So it's creating a private right of action for a data breach. But in most cases, you're going to be answering to state regulators and the like. But you also are answering to your consumer in a way, because reputationally, these things, that's where you get nailed the most, is if an enforcement action, for example, is brought by the Attorney General of a certain state, and it's made public, which they are, then that becomes a PR issue. So in a way, the marketplace is who you're getting in trouble with. But in large part, though, you're going to be running up against government regulators, at least at this point. I mean, and again, there are, as we've seen in these accessibility cases, the plaintiff's bar is very crafty in terms of what they're trying to get get into courts. I mean, the latest rage of suits that we've seen is Meta and Instagram and other platforms are now being class action sued for creating addictive platforms that are causing mental illness in young people, and it only takes one very aggressive savvy plaintiff's attorney to create a lawsuit that may have some sticking power. So not to say that you're always out of the woods on the consumer side, but Jenny, any more that you see in that realm?
Yeah, I think just on the consumer side, like you touched on, it doesn't even have to get to an attorney general, for a reputational issue. So if you're, you have a data request from a consumer, you have in your privacy policy saying that you'll respond and you don't respond, there are forums and other places online that can sort of explode in a way that can look really bad for your business, even though it's not a legal liability or it's not raised to an enforcement level with a state attorney general.
Very true.
We had 2 more questions come in. It is 11. Do you guys want to make these the last 2?
Yes,
to answer? I will be sending around an email later today. And so please feel free to reach out to Matt or Jenny later if you have more questions. So the next one is, what are the consequences with regulatory enforcers finding a breach? So like fines, a shutdown of the website, or the means to collect information?
Well, there's a couple of different concepts there. The breach, if it's a data breach, for example, or if it's a non-compliance with a statute, these statutes all go hand in hand with what are known as consumer protection statutes. Every state in the country has one of these. There's the FTC Act at the federal level. The state level, we have like the Vermont Consumer Protection Act, and those are sort of omnibus, again, fairness-based statutes that exist to be vehicles where if you have a data breach, for example, and the Attorney General decides to investigate you and determines that your data practices were just all over the map and deficient, that's deemed to be a violation of consumer protection statutes, and you can get you can be fined. You have fines and penalties. Certain types of injunctive relief, possibly to stop, to rectify what they see as deficiencies. If the website is a complete source of a problem, there could be, again, injunctive relief orders to fix the website and the like. So it sort of runs the gamut. But many times though, it is going to be fines, penalties, and then again some injunctive for situations like this. And again, I'll turn it over to Jenny for any more she has to add.
I think that's completely right. And at like the FTC level, if you get in trouble, they can sort of put in a plan in place that requires you to do a number of things, and they won't impose fines until you get to that point. So there sometimes is sort of a step in between, the initial issue and a fine, but eventually down the line, there definitely are fines or other injunctive requests that can be made.
Yeah.
Last question is if you could just touch on what written security plan entails. So would it be what the company would do if a breach were to occur, who to contact, etc.?
Great. I happily would. And that's part of it. To answer the question, it also starts with some one of the biggest things that the security plan has is step number 1 is who is our internal and external team that we're going to be working with, who is in charge of our privacy planning here in the company, who are the various people who are going to be on our internal team. There'll be someone from IT, there'll be someone from HR, there'll be someone in management, there'll be someone in other areas, physical security if you have physical security issues. So that it's you define a team. You define, what are your access policies going to be for data? What are your use policies going to be for personal information? All that stuff, again, goes back to knowing what you are and what you're doing. So it starts out with all that, figuring out, what we have, what we're going to be doing with the data, what restrictions we're placing on it internally, what are the do's and don'ts. And then you're also going to have things at the back end, which is going to be, well, what if we have an issue, right? How is this going to play out? who's, what's the chain of authority here? Who are we going to contact? Who are we working with? What vendors do we have in line? All that stuff is important to note, is important to get figured out now rather than later. And I should say, as I mentioned earlier, that the level of planning that goes into a security plan is really going to be commensurate with the level of risk you have. I mean, it's, again, in general, if you're collecting a lot of sensitive data, then the risk of potential injury down the road is always higher. And so I want to keep that in mind as security plans are being developed. And again, there's never a one size fits all in this. It's a process of getting what's right for the organization. But those key pillars, the number one is that getting that team in place, figure out who we've got and whose responsibility is for what, number one importance. And then again, practices, limitations, restrictions, policies, and then measures to deal with issues. Jenny, anything more to add?
That sounds exactly right. I think the one thing is sort of in written information security plans and sort of the internal policies is also a pillar of like education within your business. So, if someone knows that there's a breach, who should they reach out to, and do they have the wherewithal to know who to go to? So a lot of the times, in Massachusetts in particular, written information security plans are often widespread through the organization, signed by everybody, and not just a plan that's sort of saved in one place and inaccessible.
And Jenny used the $64,000 word, shame on me for not, education, right? That's another big part of it. And it's educating people on what to do, right, in incidents, but it's also, and we do this here at DRM, we do training all the time on data security. And that includes training where we're looking at, periodic videos, from a vendor that we use. It's also, though, we have, fake phishing being done all the time on us to make sure that we are able to spot this. I mean, and so training is huge in this. Education, it's, understanding that, that this responsibility, although the company's got to have, key people who are going to be the key stakeholders and key decision makers, everybody's got to have a role here, right? Everybody is just as important as everybody else when it comes to complying with these. It takes one person to click on a phishing email that exposes the company to all kinds of problems, right? It just takes one person. And a lot of times that happens because they haven't been trained to either recognize an issue or to even be thinking about it in the first place. And no, there's no way to undereducate yourself in this realm. Critically important. Now, Jolie, there's also a question in the Q&A, that one of the ones you already addressed.
I think it's just a thank you. So,
Yeah.
Well, to that I say you are very welcome, and of course I say thank you to everyone who's come out to be with us. We appreciate your time, your attentiveness, the questions. Very very good questions. We are all very real world questions that come up a lot, and we're happy to be a part of your team to solve these. And again, like I said, our job as we see it is to be part of a team with you, and not to be the black box. We want to be people just like you and solve these problems together. And so that's all I have. Jenny, any parting words for you?
Just want to say thank you. Feel free to be in touch.
Have a wonderful day, everyone.
Have a great day. Thank you.